Yeah, so next up we have Anthony Schutz from he's a professor at the Nebraska College of Law. He is one of our experts on ag and water. Anthony has been talking a lot about right to farm because we've asked him to weigh in on his professional opinion slash understanding of some of these issues. Just because of our discussion last year around this topic, we felt like the SLPC needed to have a little deeper understanding of the topic so that we can, if we have policy, that we can have a good discussion. So Anthony, we're glad that you're with us, and I would ask you to kind of dive right in on what you have for us this morning.
Sure. Can you hear me all right?
Yep, I can hear you.
Okay. So I've got one little PowerPoint here. It's got the language on it. Give me just 1 second to arrange things. I'd like to show, let's do this. All right, can you now see my screen?
Yep.
Okay, all right, so we have a number of different things that go on with the Right to Farm Act. Last year, if you'll recall, Senator Keene from Minden brought forward a proposed constitutional amendment. It went to the Agricultural Committee, and basically that constitutional amendment was designed to create what many refer to as a right to farm. Whether it does so or not sort of depends on what you might mean by that language, and more specifically, it depends on what exactly this language means. So at this point, what we're doing is sort of looking at the upcoming session in anticipation of something coming. And it'll probably be something along the same lines as the language that was proposed in the last session. And so I think what we need to do is at least have some understanding of objections that people might have to this language, or thoughts that arise from sort of reviewing it. I'm a professor. I teach in a law school, and I study agricultural law and state constitutional law. So I'm kind of uniquely situated to deal with some of the legal issues that arise with regard to this. And so I want to cover that ground here this morning for, I don't know, for about maybe a half hour, and then open it up to questions. Generally speaking, there's three lines of issues, I think, that arise from the language that was proposed last year, or more broadly, just efforts at regulating, creating a constitutional right for agriculture. Now, Nebraska, of course, wouldn't be the only state to do this. There's two other states that have adopted provisions that are similar in some ways to these and different in other ways. North Dakota was the first to adopt a provision a few years ago. Missouri adopted a provision, I believe it was last year or the year before. Oklahoma has one on their ballot. It'll be voted on in this general election next week. Indiana has considered but rejected a provision like this. It didn't go to the voters. It just didn't make it through the legislature. And I believe it was Montana that had a similar fate, that befell a provision that was proposed in their legislature. So these things are starting to become more and more, I guess, common, at least insofar as they're being considered by state legislators, if not state voters. So in Nebraska, we have this provision that was proposed last session, and I think there's really sort of three general categories of concerns that one should think about when trying to figure out whether it's something they want to support or not. The first is sort of the broadest, and it doesn't necessarily pertain precisely to this language, but in some ways it does. So let me sort of explain that a little bit. There's a big sort of policy question, which is agriculture in need of protection from a particular state's legislature, right? Specifically, Nebraska's legislature in this particular instance. So does the agricultural community in Nebraska, that is farmers and ranchers, and I think we could agree that those are sort of the core folks that we would think of in the ag community, are those folks in need of protection from the Nebraska legislature, or do they remain protected from that Nebraska legislature by way of their political power, right? And I tend to think that the answer to that question is Probably not. That is, we probably don't need a provision like this. That is, that they probably do wield, the agricultural community probably does wield enough political authority or political power within the legislature that we can count on that legislature, at least to protect agricultural interest when it is necessary to do so, right, or when it's appropriate to do so. And that's sort of the ebb and flow, I think, of policymaking, and the questions that we run into often aren't clear, sort of black and white, ag should win, ag should lose sorts of questions. They're questions that are more nuanced, like, for example, how are we going to fund public schools? Well, we've used a property tax in the past, we've used it for particular reasons, but now it's having an adverse impact on agriculture. Does that mean that we hate agriculture and we love schools, or that we hate schools and we love agriculture if we change it? Well, no, it just means that we have got a very difficult situation in front of us, and it's hard to figure out what the appropriate response should be. That doesn't necessarily mean that a legislature is hostile to agriculture if it has to engage in those sorts of give and take balancing acts. So when I look at the legislature over the past 10 years that I've been a law professor, and 20 years that I've been sort of old enough to pay attention to it, I haven't seen our legislature take any actions that are hostile to agriculture. And if that's the case, if there's not a big threat facing agriculture, then I question why we would even consider using language that would restrict the legislature's ability to have any sort of an impact on agriculture. But that's sort of it's a professional opinion, but it's also sort of a judgment that I've made based upon my experience. People are, of course, free to make their own judgments with regard to that, and I don't know that I'm very good at sort of helping you think through that sort of broad question. So we'll leave that one out there. If the answer to that question is yes, we do need to regulate, we do need to restrict the legislature in some way, well then we have to figure out exactly how or what we think we should restrict the legislature from doing. And so that's where the language comes in, right? If you don't consider the language that's utilized in the provision, you don't have really any sort of understanding of what the thing might do. If you don't have any understanding of what the thing might do, then you don't really have a very accurate appraisal of what you think the dangers associated with the legislature are. So what I would encourage you to do is, once you decide that yes, agriculture in some form does need, to some extent, some protection from the legislature, you have to take the next step and try to figure out what exactly that protection should be. And this provision has language in it. This provision has language in it that makes choices about what exactly the dangers are facing agriculture and what exactly we ought to restrict in the name of protecting this so-called right to farm. And so we get into, I think, a more fine-grained policy analysis of, okay, what exactly is it that we're trying to do? Okay, so my first issue, these are sort of my lecture notes over here, and this is the language of the provision over here, but my first sort of policy issue is, who does this provision restrict and what does it protect agriculture from? Now, in order to understand the language of this provision, you have to read it fairly closely and I think parse it out. This first part of the language, to protect agriculture as a vital sector and as the foundation and stabilizing force of Nebraska's economy, it's sort of surplusage. It might be helpful down the road in terms of trying to interpret this provision or something along those lines, but it doesn't really add a heck of a lot to what we're trying to do. So I think we can delete that at this point and look in on this particular language, which gives us 5 lines of text. And it starts with, the rights of citizens and lawful residents of Nebraska to engage in farming and ranching practices shall be forever guaranteed in this state. Okay? And we can sort of stop there and look at just this provision in contrast to this provision. And I think that's one way of reading this provision, that there are in fact 2 rights that are being created by this particular language. The first is the right of citizens and lawful residents to engage in farming and ranching practices, and that right shall be forever guaranteed in this state. That provision by its terms, and I think even considered in broader context, doesn't have any exceptions associated with it or anything along those lines. It's just a broad grant or a broad recognition of this right of certain people to engage in farming and ranching practices, and it shall be forever guaranteed. Now, I started off, though, with who does it restrict and what does it protect ag from? Well, who does that right restrict? Well, that right shall be forever guaranteed. Well, forever guaranteed by whom, right? One answer is the legislature, but again, there's no language here that ties this right specifically to the legislature. So maybe it's broader. Maybe it includes not only the legislature, but also executive agencies, the governor's office, courts. I mean, if this right is to be forever guaranteed in this state, that would probably mean everybody in the state needs to observe it, and that would include all of the different arms of government that are in play. So that's one version of one part of this provision that sheds a little bit of light on sort of what it does and who it might protect and who it might restrict. The second piece of the provision, and note the comma and the and, right, and the legislature shall pass no law which abridges the right of citizens and lawful residents of Nebraska to employ ag technology and livestock production and ranching practices without a compelling state interest. This right is narrower in a couple of different ways, but the way I want to focus in on right now is the notion that this one only applies to the legislature. So in other words, this creates a right to utilize, I think, agricultural technology, whatever that may mean, as well as, and I think what it's getting at, the grammar's not very good, but I think what it's getting at is the notion that if we're going to produce livestock, farmers or ranchers and farmers and livestock operators and feedlot owners and all of those sorts of folks ought to have the ability to utilize the sorts of practices and production techniques that are utilized within that industry without the legislature interfering. But again, this provision only applies to the legislature. That's the only person that it restricts, or the only sort of thing that it restricts. Now, that may or may not be sort of a broad restriction. The legislature, I mean, that's the unicam, and that's one piece of government, but there's a lot of government that gets its power from the legislature. So local governments get their authority from the legislature. That would include your school districts. It would include natural resources districts. It would include public power and irrigation districts. It would include any agencies that are created by statute as opposed to the state constitution. So the Department of Natural Resources gets its authority from the legislature. The Department of Environmental Quality gets its authority from the legislature. And so there's an argument that if you restrict the legislature from doing something, you, by implication and necessarily, restrict any entity that gets its authority from the legislature. And the reason that is because if you held otherwise, if you held that these other agencies that derive power from the legislature wouldn't be restricted by it, well, what you're really saying is that the legislature can do indirectly what it can't do directly. That is, the legislature cannot directly abridge the right of citizens to farm, right? But it could do it indirectly by, for example, giving the Department of Environmental Quality the ability to do that sort of thing, right? And so if we're going to rein that in, if we really want to have a restriction on the legislature, then we would need to interpret this provision, I think, to restrict those subsidiary levels of government, that is, those levels of government that derive their authority from the legislative body. Now, that would be open to debate, of course, because the provision only says the legislature. And in debate, the last session, the question of who should be regulated did come up. Who should be restricted under the constitutional provision did come up. And what we concluded from many discussions was that, well, you know, it's just the legislature that we're worried about. We're not worried about local governments. We're not worried about counties that zone or those sorts of things. And so they would interpret this language to include only the legislature, but they also wrote some exceptions to the provision that were proposed in debate that would have exempted those subsidiary levels of government from it. So it's a fighting issue. I don't know exactly how the language would be interpreted, but the way the language is now, it is, I think, confusing at best, right? This right, the narrow right to utilize technology and some livestock practices, only pertains to the legislature, but the broader right to farm and ranch shall be forever guaranteed in this state, presumably by protecting it from interference from all actors in government. So, who does it restrict? Well, maybe everybody in some instances, maybe just the legislature, but the legislature might be a broader sort of notion, that is, it might include those subsidiary parts of government that derive their authority from the legislature. Now, what does it protect agriculture from? Well, shall be forever guaranteed in this state. What does that language protect agriculture from? Well, I presume anything that would interfere with this right to engage in farming and ranching practices. So in other words, we would need to know what exactly it means to engage in farming and ranching practices. And note the language that's chosen here, right? It doesn't say to farm or to ranch. It says to engage in farming and ranching practices, which presumably is something different than just farming or ranching, or is a part of farming or ranching, or something along those lines. So the language that's been chosen here, I think, is somewhat cumbersome and unclear at best, and in need of interpretation, which is a point that I will get to down the road. But what exactly does this protect agriculture from, this first right? Well, anything that falls within the scope of farming and ranching practices would necessarily be protected. In other words, it would be, under the terms of this provision, forever guaranteed. And so that seems to be a fairly strong protection for agriculture. The second provision, though, seems to be more limited. That is, while the first one doesn't have many limits on the scope of protection that ag would get, the second one does. And the second one says that the legislature, again, that can be interpreted narrowly or broadly, shall pass no law which abridges the right of citizens and lawful residents to employ ag technology and livestock production and ranching practices. So here we're protecting the right to utilize ag technology and utilize these production and practices. Note again that the grammar is somewhat off. So the legislature can't abridge those rights. What would it mean to abridge those rights? And that's a difficult question. It would be one that is subject, I think, to interpretation. Abridge could mean anything from totally restricting the ability to utilize ag technology, or it could mean anything that makes the utilization of agricultural technology more difficult. So, for example, let's take glyphosate as an example. A total abridgment would, of course, be a ban on Roundup, right? Another way of reading abridgment would be those laws that, for example, would require reporting, or they require maybe, like if you didn't have any federal law, if you only had state law, and state law required the use of a label and producers to sort of observe label restrictions, well, that might be the sort of thing that abridges one's ability to utilize agricultural technology. So, in other words, you could interpret this quite broadly to restrict a broad range of laws that have any sort of an impact on agricultural production, specifically the use of agricultural technology, right? Or you could interpret it narrowly, and it would only restrict the legislature from passing laws that totally take away the ability to utilize a particular agricultural technology, under my example. Now, that's not to say that the legislature can't do that. It's just to say that if the legislature wants to do it, it has to have a compelling state interest to do so. And those compelling state interests are historically interpreted to include only the most significant state interest. I don't know that a broad-based concern about environmental harm would be enough. If you had a focused concern, like if we had good evidence that glyphosate in the environment was causing pancreatic cancer or something along those lines, that public health concern, that fine-tuned into that particular product would probably justify, would be compelling enough to abridge the right to utilize Roundup and agricultural technology. But that would be, you know, given a strong interpretation of the term compelling, that would be what we'd be looking for, is that sort of a thing. So, what's it protect agriculture from? Well, any laws that abridge these particular rights that are unjustified in the case of the second one, and in the case of the first one, basically everything, right? It seems to protect agriculture from basically everything, or at least that's one interpretation of it. Now, in the course of adopting this provision or proposing this provision and debating this provision, a number of exceptions came up. Because I think when people read this, I don't know that if they went so deeply as to parse the language and actually try to figure out what are the rights that are created, but one thing they looked at it more generally and they said, well, look, this is going to skew the legislature's ability to make judgments between agricultural interests and other sorts of interests. And in some instances, these other sorts of interests often do outweigh the costs that are being imposed on agriculture, right? Not an on-off switch, remember it's a lot of gray, but in some instances we want to allow the legislature to operate independently of this restraint that seems to tip those scales in a different way. And so we came up with exceptions for water regulation, we came up with exceptions, again, I mentioned for local governments and those sorts of things. And I think what that tells us is that in many instances, when we get into the actual weeds when it comes to policy making that affects agriculture, we often find the trade-offs are important, right? The trade-offs have to occur, and that there is no real good answer as to who should win and who should lose. In fact, there's just exercises in judgment trying to get to the best outcome that serves everybody's interests as opposed to any particular sectors of the economy. So I think the existence of those exemptions that came about in the debates surrounding this provision, it sheds some light on that, and is pretty good evidence that when people really get into the weeds on whether agriculture should be protected in a strong way from the legislature, they tend to waver, right? They tend to say, well, yes, but water is pretty important. Yes, but local government regulation is actually a fairly important way for local governments to sort of exist and do something and make their environments or local economies better. And so, you know, it's not to say that one is necessarily better than the other. It's just to say that when people, I think, got into the weeds and looked at this, they said, man, this balance is difficult. I'm not entirely sure that we should impose this restraint when it comes to water regulation, for example. And so they wrote an exemption that would exclude it. Okay. So enough of that. Those are some of the policy issues I think that arise. First, at a general level, do we need this? And then at a more specific level, well, who should we restrict and what should we restrict them from? And this language has made choices with regard to that. And of course, there would be other choices that could be made utilizing different language. Okay, constitutional issues is the second round or the second category of things that I think are important to consider. You know, I debated on whether or not I should cover this first, but the main constitutional issue, and this is an issue that arises under the federal Constitution, because we gave Congress the authority to regulate interstate commerce, right? That has also meant, sort of by implication, that states are restricted from interfering with interstate commerce too much, okay? And one sort of very basic way of interfering with interstate commerce too much is for a state to discriminate against out-of-state commerce. So, for example, if Nebraska said that cattle from Kansas could not be fed within our state, that would discriminate against interstate commerce. Discriminating against a product based upon the location at which it's produced or the location where the people who own that product exist, right, or live. And so we couldn't say Kansas cattle couldn't be produced or couldn't be fed here if they're owned by somebody who's in Kansas, or if they're born in Kansas or something along those lines. That would discriminate against interstate commerce and be clearly invalid under those restraints that arise by implication through the existence of the union and specifically the creation the vesting in Congress with the power to regulate interstate commerce. So we can discriminate against interstate commerce, but this provision does precisely that by protecting agriculture, clearly an economic activity, clearly an industry that has significant interstate commerce aspects to it, even international commerce aspects to it. This language says that only citizens and lawful residents of Nebraska are protected from the state legislature. In other words, if you're a Kansas feedlot customer and you have cattle on feed in a feedlot in Nebraska, and you want to challenge under this provision an environmental regulation that you think is depriving you of the ability to farm and ranch, to utilize livestock production practices or ranching practices, well, you're out of luck, because this provision only gives that right to citizens and lawful residents of Nebraska. And that's clearly unconstitutional under the federal Constitution and the implications that arise from the Commerce Clause. And so, you know, this was the reason why I-300 got struck down, right? It was because it required, at least the interpretation was, that it required people to actually live in Nebraska in order to utilize the corporate form. It was also adopted with a discriminatory intent that was derived from that interpretation, but this is definitely a problem when it comes to this particular provision. And what it means, I think, basically, I don't think there's really any argument about it, is that you have to strike that language. it cannot only pertain to the rights of citizens and lawful residents. It can't only apply to Nebraskans. If we're going to protect the Nebraska feedlot owner, we have to protect the Kansas feedlot customer, the Kansas feedlot owner, the North Carolina hog operation. All of those folks have to be protected because they are all engaged in farming and ranching within the state. And so they would need to be protected as well. And all of the other rights that we have in our Constitution apply to anybody who's here, right? You don't have to be a citizen, you don't have to be a lawful resident or something along those lines. People in Nebraska, as a matter of being in Nebraska, are protected by our state constitution. So that language would have to be struck. In addition, if the language were to somehow remain, and I don't think it can, but if it were to somehow remain, this language also only mentions citizens and lawful residents, which are two categories of actual people. It doesn't seem to pertain to, it doesn't seem to apply to entities like LLCs or corporations or those sorts of folks. But really, I don't think that matters because I think the language restricting it to Nebraskans is actually clearly unconstitutional and would result in this thing being struck down the road. So I think what we can do in terms of evaluating this is perhaps just strike this language. This clause, which makes it a little bit easier to read, actually. So the first right, the right to engage in farming and ranching practices, shall be forever guaranteed in the state. The second right, and the legislature shall pass no law which abridges the right to employ agricultural technology and livestock production and ranching practices. This language, I'm going to basically just do this because I think it makes things cleaner and it avoids problem. I don't know if livestock production and ranching, it would seem to me that ranching is part of livestock production, and so we could just boil it down to this: agricultural technology and livestock production practices as our focal points, and it makes it a little bit cleaner. At least it makes the grammar easier to understand. Okay, so if we get the constitutional issue out of it, we provide people, including entities in the state, out of state, with the right to engage in farming and ranching, and then this further right to utilize agricultural technology and livestock production practices. We're left with, I think, the language that we could interpret. Now realize that we did a little bit of interpretational work back when we were considering the policy issues and the specific policy issues that were here. So it's not like this is new territory in toto, but there is some further things that we have to consider. When we talk about people versus entities, I think that issue doesn't arise because I think that language gets taken away by striking the unconstitutional language. So to engage in farming and ranching practices, what does that mean? Now, we all know how difficult this can be, and I heard just at the tail end of the last presenter, he's got some stuff on actively engaged and those sorts of things. Well, some of those same issues arise here. Now, this provision doesn't pertain only to people who are actively engaged in farming. If it did, then we would have the issue of trying to figure out what that means, right? Does it require you to provide labor? Does it require management? Does it require a particular capital contribution? What does it mean to be a farmer or a rancher in sort of common terms? We know that that's a very difficult thing to figure out. This provision doesn't take that route. It doesn't try to identify people as farmers or ranchers. It tries to protect the utilization of farming and ranching practices, right? And so it's trying to get at sort of the things that people do when they're farming. And I think that, you know, it's a different view on what it means to farm. I don't know that it helps us get to anything that's more concrete. I mean, what is a farming and ranching practice? It would seem to me that accounting is a very important farming and ranching practice. So is the right to engage in agricultural accounting forever guaranteed in the state through this provision? Cultivation, right? You know, going out and actually tilling the soil seems to me to be a farming practice, and that is now a right that is forever guaranteed in the state. I guess pulling calves on my own ranch, right? Is that a right that is now forever guaranteed in the state? And maybe it is, maybe it isn't, but realize that we're sort of core things that we think of as being farming and ranching, and then there's all of these other things that are part of farming and ranching that are necessary to it, but now seem to be elevated to constitutional rights, which I think is interesting. In addition, if we think of this as trying to protect the farmer or the rancher, we often find the farmer or the rancher sandwiched between two sort of very powerful interests. On the input side, we've got the input suppliers, right? We need access to seed, we need access to genetics, we need access to all of those sorts of things in order to successfully farm and ranch. And on the output side, right, we need access to markets, we need interim financing in order to sell commodities. We need lots of other things, and we're sort of price takers on that side and all of that. And so the question I would ask is, does the right to engage in farming and ranching, does it further restrict these other parts of the system? On the input side, does it have an impact there? On the output side, does it have an impact there? And what impact does it have? Furthermore, what is a farming and ranching practice? I mean, we can kind of fall back to that. Is industrial production a farming practice? Is the operation of a 90-foot boom sprayer spraying Roundup or dicamba or something along those lines, is that a farming practice, or is that something else, right? Is that sort of an industrial sort of practice, whereas our farming practices is sort of our Jeffersonian notions of things along those lines? I don't know, right? I don't know. We would have to interpret the language to try to figure that out. And in interpreting this language, what a lawyer would try to do is make arguments about what the people who voted for this were thinking when they voted for it, because that's the intent that matters. Not so much the drafters of the thing, but really the intent of those people who adopted it and made it part of the fundamental law within the state. Because remember, this is a constitutional amendment. It'll go to the people to get adopted, and it's their intent, it's their desires that matter with regard to this. And so if we think that they're not thinking about industrial agriculture as farming and ranching, well, then we may not be able to interpret this provision to include those folks and protect them. In fact, it would seem to me, given the language that's used here, that the drafters don't even think agricultural technology and livestock production practices are farming and ranching practices. Because if they were, why would you include both of these provisions, right? If agricultural technology and livestock production practices are simply farming and ranching practices, well, we've already forever guaranteed them. So why would we feel the need to speak more to ag technology and livestock production? Well, maybe it's because we don't think ag technology and livestock production are within the scope of farming and ranching practices, but that seems like a strange result. It could be that we think agricultural technology and livestock production practices are farming and ranching practices, but they're not of the same order as those farming and ranching practices that shall be forever guaranteed. So with regard to these things, a subset of farming and ranching practices, we do want to allow certain folks other than the legislature, to regulate them, and we want to allow the legislature to regulate them if they're justified in doing so. Now, I've done a lot of work here in trying to interpret this provision. Who's going to be charged with trying to interpret this provision going forward? Is it going to be some law professor in the ivory tower? And the answer to that's no. Is it going to be the legislature? The answer to that is also probably no. In fact, the people who are going to be charged with interpreting and applying this provision are first and foremost the judiciary. And that raises that I think puts agricultural interest in an interesting position, because we do a lot of griping in other contexts about active judiciaries and basically having courts interfering with legislation and courts interfering with this and that. But this provision would empower the judiciary to figure out what sorts of farming and ranching should be protected and what sorts of farming and ranching should not be protected. And I think that's definitely a question that one has to consider. Do we really want the judiciary making this decision, or would we rather have the legislature doing it? Do we want to open up the door to further litigation, or don't we, is another way of thinking about it. And I can go either way on that particular question, because litigation is clearly, even if it's not intended to be, it sometimes is a way of sort of driving policy development and things along those lines. So So I don't know, there's a lot of things to consider here, but hopefully I've shed some light on why the language in this provision becomes somewhat cumbersome, somewhat complicated, and probably needs to be seriously thought out before you can figure out whether or not you support it or don't support it. I mean, in theory, sure. I mean, I get the idea. I'm pro-agriculture. Everybody that I know is pro-agriculture. I don't know anybody who's not pro-agriculture. Everybody's pro-food, right? We all want food. We want it at affordable prices as well. So I think by necessity you have to be pro-agriculture. But what does that mean, right? What type of agriculture? Do we want to protect farmers, or do we just want to protect the production that's coming from those farmers? All of that gets us into sort of difficult policy land. And this provision is kind of a pretty ham-handed way of trying to deal with very complex and I think difficult judgment calls that we have to make. And our typical means of answering those difficult questions has been to create a legislature, right? And then have that legislature make these decisions with the influence of lobbyists, with the input of constituents, with all of the data that we can get to that particular entity. And when things get too technical, often we'll create administrative agencies to deal with it. But that's the apparatus that we have. We don't typically have constitutional provisions that answer significant questions of important policy outcomes in situations where we have sort of a very complicated political matrix to deal with. So that being said, hopefully I've shed some light on this, and I'd open it up to any questions that I might be able to answer.
Great, Anthony. I appreciate that. It sounds like we do have at least a couple questions here.
Yeah, Anthony, we do have one question here, and it is basically, in previous years, I have thought that the right to farm was basically a means to stop the minor lawsuits, the nuisance lawsuits, such as my corn shucks blowing into a city person's lawn and so forth. But I know the idea of this is to stop HSUS and other organizations from making changes to our modern ag practices. Is there a way that such a bill could accomplish both goals?
Well, I think so. The nuisance protection, the protection from minor lawsuits, from the quintessential example we have of that is a city slicker who moves out into the country because they want to have this nice acreage, and they build a $500,000 house, but they fail to realize that they built the $500,000 house a half mile downwind of a 200,000 head feedlot, right? And turns out that that's not the best place to live. And so what they wind up doing is suing that feedlot operator and saying, you're interfering with the use and enjoyment of my property. And that actually is kind of a difficult question for courts to figure out. On the one hand, the feedlot was there first. On the other hand, this guy made a significant investment, and we would presume that he didn't know, or maybe shouldn't be charged with knowing about the situation he was in. And so sometimes courts have struggled with that. And when courts have struggled with that, people have gotten upset and said, no, the agricultural interest should clearly win into that situation. And so they passed laws to protect these agricultural interests from these nuisance suits. Those exist in every state. Nebraska has one. Nebraska actually, relative to other states, has a fairly strong one. All you need to do in Nebraska is be there first as far as being the agricultural defendant entitled to a win under those provisions. So we have a lot in place with regard to like nuisance suits and things along those lines. So I don't know that there's much room or much need for further protection in that scenario. Now, with regard to HSUS, I think one has to consider, a realistic appraisal of what exactly it is that they would accomplish, but maybe more specifically how they would go about accomplishing it. Okay. Now, the successes that HSUS has had thus far have pertained to three things, right? Veal crates, gestation crates, and chicken houses. Those are significant, I think, from an agricultural producer's perspective, but they just so happen to be the sorts of things that when you see them, they're somewhat alarming, even to, my folks, right, who've been farming for a number of years. I think when a lot of us look at a veal crate, we tend to shake our head and say, wow, what exactly are we doing there? So I can see how that resonates with the general populace, and that's why HSUS has had success, because we have to consider how they go about achieving their success. And the way that they've done it, in most instances thus far, has been through a popular initiative, that is a petition that was circulated, to amend the state constitution, okay? Now, I don't see any proposals to take away those provisions of our state constitution. That is, provisions that would take away the ability of people to write a petition, to get it before the voters, and then to vote on changing our state constitution. I haven't seen any proposals to do that. That would head HSUS off, right? But I don't know that we're going to throw the baby out with the bathwater over HSUS. So if that's their vector, if that's the way that they would want to, or in probably the only way that they would be successful, and again, they would have to garner the support of a majority of the populace in Nebraska, which I think would still be a difficult proposition. But even if they were going to do that, this provision wouldn't affect that at all, because this amends our state constitution, says farming and ranching shall be protected. But if you also amend the state constitution to prohibit some aspect of ranching or livestock production, well, you've just basically amended by implication the provision that you adopted before. So in other words, this doesn't have any impact on the ability of HSUS to come in with a ballot initiative and amend the Constitution to get to where they want to go. And it's really that's been the only real example, I think, of their success, is to utilize that way of doing it. Because when they go to state legislatures, by design, the state legislature doesn't have, the state legislature is ill-suited to make that sort of broad-based sweeping judgment, right? Because the lobbyists are going to be there, the other side's going to be there, the constituents are going to be there. It's not just going to be HSUS with an ad campaign that convinces the decision maker to make a decision in the absence of any other information from somebody else. So, I mean, to the extent we could keep this debate in the legislature, I think that's the appropriate place for it. We don't really need any provision to do that, because that's where the debate already is. And to the extent we try to sort of shore up the legislative process against inroads on that or dangers associated with it, like I said, I think we raise a number of interpretational issues that are quite difficult. So in other words, this might simply be a lesson to sort of trust the process that's there and then be prepared to engage in the debate when it comes, right? If HSUS does come to the state legislature and starts proposing restrictions on the use of veal crates or cages or chicken houses or those sorts of things by statute, well, Farm Bureau is going to be there, cattlemen's going to be there, poultry producers are going to be there, and try to tell the other side of that story, which is going to relate to production costs and animal rights and all of that sort of stuff. And then the legislature will be tasked with making a difficult judgment. But that's what they do, right? And that's why we elect them to do that. So I tend to think that the process is there, that we don't need to try to deal with a problem that we already have an apparatus set up to deal with. Hopefully that answers the question.
Great, Anthony. I think it's been very helpful to get your thoughts, and that's one of the things that we just really wanted to do with our committee as we got into looking at policy and policy ideas. We just need to make sure that we had a solid background of information to deal with to help us make good decisions, and I think you've really brought a lot of those things to the table that are important for this committee to understand. So thank you for being a part of this. I think I'm going to turn back over to Jay Ferris. He has a couple of housekeeping things for the committee, and we will keep moving here.
Yeah, thanks for having me.
You bet.
Yeah. Thanks, Anthony. Yeah, thanks, Mark. Yeah, a couple of things that do want to go over, or I just couple of housekeeping tips before next week when we meet. We are planning on meeting Wednesday evening for supper at 6:30. That'll be a joint session with the Council of Presidents, and then following that meeting, it will allow you to have some time to meet with your subcommittees and go over some things for the next day. As well as with that, speaking of subcommittee assignments, if you have not requested which subcommittee you would like to be on, please get those into Whitney or myself this morning, because this afternoon we're going to be sitting down and making those assignments for what subcommittee you will be appointed to. We have most everybody that has done that. Also, if you haven't indicated to Whitney what night you need motel rooms for in Kearney next week, please do that as well. And so with that, there is a place on the webinar, it's under handouts, and that has a sample agenda. We will be sending that out as well today. You can download that here before we end the webinar this morning. Also, there is a handout on the right to farm issue. There's our policy guide that we sent to all the counties for to get some of their questions answered, or some of our questions answered. And so we're getting those policy resolutions from counties now, getting that formed into that document, and we will be getting that out to you as well, probably tomorrow when you will see that. And that will be in email. So be checking your email. You'll be getting notification on which subcommittee you're on. We'll get the draft outlines out to you as soon as we can get them done. And anything else. Are there any questions? I'm going to, any questions or comments, please get a hold of me. We can do that as well, or Whitney. I'm getting over here. I can actually unmute everybody's phone, or, well, I guess I can't for some. There we go. So if you have anything, you can type it in. You can raise your hand. We can unmute your phone. But with that, want to thank everybody for being on the call this morning. Mark, anything else from you? Or I know Bruce and Ansley are on, and I believe Jordan is also on. So anything from anybody else? Okay, well with that, I am going to say we are done for this morning, and we will see everyone next week in Kearney.